Friars Village versus Hansing arose from a fact pattern with a very intent civil engineer who is retired. Mr. Hansing is a gem of a gentleman. And we had a situation for an association down in San Diego. The association contacted us and said, you know, we're not really comfortable with our general counsel. We are going to trial in 15 days. And we'd like you to come try that case. We did try the case. We prevailed at Superior Court. And Mr. Hansing appealed. And the issue was that the association had enacted, and properly enacted, I'd like to say, properly enacted a rule and regulation, an election qualification pursuant to Civil Code Section 136303C, which states that you shall pass election qualification rules. And that was part of the big move about 3 years ago to get election rules in place. And as part of election rules, you were able to set criteria for people who ran for the board. And so they passed an election qualification rule that said, if you're married or you have somebody in your household, you can't serve concurrently. If they're serving on the board, you can't run for the board. And Mr. Hansing said, you know, the problem with that, it precludes me from nominating myself. If I can't get on the ballot, then you're violating the self-nomination provisions of California Civil Code. And this is something that, as an industry, we've had symposiums on. We've talked about what would a court do? What is a court going to do? And gosh, weren't we lucky? We were the ones who got to try it now at the Court of Appeal level. The election qualification rules were in addition to what was in the bylaws. So the bylaws had provision that said you had to be a member, you had to be an owner, you had to be a resident within the community, which I think is an interesting rule. I have a less of a right because I'm not an owner within the community. But this new rule, about 3 others, you can't be a felon, you can't be in addition to what is in the bylaws. And Mr. Hansing took the position that under the bylaws, he had a right to run. He's a member, he's a resident, he has a right to run. And our rule violated his right under the bylaws. So the question became, what is meant by a conflict, right? Because we know that we can't pass a rule that conflicts with a bylaw or a CC&R. Well, is it that we can't pass a rule that directly conflicts? I.e., what if we had passed a rule that said, you can run even if you're not a member, or you can run even if you're not a resident? That, in my mind, would directly conflict with our bylaws. Or is it that we can't pass a rule that conflicts with sort of this right created by the bylaws? And that was the position that Mr. Hansing took. Are you with me? I'm nodding, I'm seeing nods, that's great. So that was our position. We said, look, it's not the question of direct conflict, it's a question, or, you know, for us, you needed the direct conflict. For Mr. Hansing, you only needed the conflict with the right to make the rule invalid. And then the question, of course, was, does that preclude Mr. Hansing from self-nominating? So the Court of Appeal came back, and we can roll to the next slide if you'd like. The Court of Appeal came back and said, look, it's not about the right. It's about direct conflict. And we had a couple of cases that the Court of Appeal seized on that they really liked. They said, look, an association has to have the right to pass reasonable rules and regulations, and unless those rules and regulations directly conflict with the language in the CC&Rs, then, or the bylaws, then we're gonna say that that's an infill rule. We're gonna say that that rule augments the restrictions or the regulations that are held in CC&Rs or bylaws. Are you with me so far? That's great. And it's really important in our industry because it's bigger than Mr. Hansing, it's bigger than Friars Village, it's bigger than community legal advisors, certainly. The question now, I think, on a go forward, now that we have the Friars Village case, is what what can we do? Because always we've looked, when we've created rules as association attorneys, is do we have authority under the CC&Rs to pass those rules? Is there some rule-making authority? And the Court of Appeal came back and said, you've got rule-making authority in one portion of the code to make rules. You've got authority in another portion of the code to make election qualification and election rules. You've got authority in another part of the code to make other reasonable rules as they pertain to the association. What we're really interested in looking at is the reasonableness of the rule. And it takes us back to really the seminal case in our industry, NARSTAT. In NARSTAT, the court said there's going to be two different standards for evaluation of whether a rule and regulation or a CC&R is valid. If it's a CC&R, they're going to presume it's valid. If it's a rule and regulation, they're going to look to the reasonableness of the rule. Does it make sense that a community as a whole would pass and enforce this rule? Is this rule reasonable as to all of the owners in the community? Does that make sense? So there's going to be two standards. Court of Appeals come back and said, we're not going to look at exactly how and when and why and the authority to pass the rule. We're really looking at, does this rule make sense for the community? So it's a big rule going forward, and it has everything to do with reasonableness as to the community. So we're very excited about it, and that rolls us to the next slide that involves very much Ms. Loomis.